today going to talk about a significant change in the new Bharatiya Nagarik Suraksha Sanhita 2023. Now, this significant change is about complaint cases. As a background, in India, one could approach a magistrate and file a complaint containing facts which disclose commission of an offense against accused persons, proposed accused persons. The magistrate would then examine the complainant and the witnesses, if any, on oath, and if based upon such examination of the complainant and witnesses, as well as the evidence produced by the complainant, it appears to the magistrate that offense may have been committed or appears to have been committed, then the magistrate would take cognizance under section 190, this is the erstwhile law, and issue summons to the proposed accused. Now, in the earlier process, there was no role for the proposed accused to appear before the magistrate before the issuance of the summons to say that no, this is the lacuna in the complaint, this is the lacuna in the interpretation of facts or the law, and therefore it is not that I have committed an offense, I am innocent. That defense, or allowing the accused to put their case before they are put into trial, was in fact being misused in India by business partners, employees, suppliers and vendors when they had a civil dispute as an arm twisting tactic. Or it always became a huge issue where one would have to go in revision to a higher court or file a quashing petition before the High Court saying that no, this cognizance that has been taken by the magistrate has been taken without application of mind, or in the facts which have been narrated in the complaint or the evidence which has been adduced, no cognizance could have been taken. Now, of course, when you are before the revision court or before the High Court, it would take its own time. You may get a stay, but of course, that sword would still be hanging upon you that you may have to face trial if the High Court doesn't appreciate and says that no, this is a matter of trial and you can put forward your defense in the trial. In many cases, of course, one had to go through the trial also before they could be acquitted or could be proven innocent. And that change has been brought about BNSS 2023. What it says, in fact, and this is one small line but makes a significant change, that after examination on oath of the complainant and the witnesses, if any, the magistrate and signed by the complainant, magistrate will take cognizance, but provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. So this basically gives an opportunity to the accused to appear before the magistrate and point out why an offense is not made out based upon the complaint and the witnesses or the evidence which has been adduced together with the complaint. But the question that still arises is that can an accused person, when he is provided that opportunity, produce evidence, a new evidence, or his version of the evidence as to, for instance, if something has been suppressed by the complainant, some documents may not have been produced by the complainant to give it a flavor that yes, an offense has been committed, and the accused person has certain documents which he can produce and show that look, this is not the whole story, something has been suppressed from the court. My view is that this particular opportunity that has been afforded to the accused person to be heard before the magistrate takes cognizance is only limited to what is on record, and this of course is a welcome change. This will reduce litigation, frivolous complaint cases or issuance of summons, which for businessmen of course has been a very big problem, because civil disputes, as I said, are often converted into criminal complaints just as arm twisting tactics.